Here to talk about the question of pre-suit mediation and its advantages. This presentation takes approximately 15 minutes. I try to be brief and to the point. If you have questions, I would ask that you use the chat function and put them in there, and we'll address them at the end of the session. I should also note that I am not affiliated with Stanford University, even though you're looking at a picture of the main quadrangle at Stanford. I am an alum, but I like this picture. It brings back good memories, but it says Stanford up on the top, and I'm not trying to imply that I'm in any way affiliated other than as a graduate with Stanford University. Lastly, we have been having some internet issues. In fact, about 15 minutes ago, our internet went out. So I'm hoping it doesn't happen again. If it does, bear with us and we'll get back to you as soon as we can. Since it just happened a few minutes ago, I think we're probably okay. Anyway, let's get on with the presentation. My name is Rick Williams, and I am a lawyer and a mediator with the Gray Duffy Law Firm. I've been in practice for 46 years and have been mediating cases since the late 1990s. Most attorneys know about and use some form of ADR as part of their litigation practice, as do many sophisticated businessmen and women. Unfortunately, most ADR, in my experience, is brought into lawsuits after thousands of hours and thousands of dollars have been spent litigating and fighting the fight, if you will. How many of us ever consider the idea of mediating a dispute before it matures to litigation? The answer, in my humble opinion, and sadly, is very few. All too often, personal, financial, or business concerns overshadow the fact that early evaluation of an issue and the involvement of a skilled third-party neutral mediator may set the course for an expeditious settlement. At a minimum, a pre-suit mediation can build a bridge over the risks, known and unknown, which can consume resources and have a destructive force that prudence would tell all parties to avoid at any cost. Why is pre-suit mediation the answer? Well, first, as this slide indicates, you need a dispute, and the question becomes, is the dispute ripe for mediation? Also, at the outset, you need to address if there's a contract involved, is there a dispute resolution clause in the contract? Most clauses, if they're appropriately drafted, and that's really a subject for another discussion, are enforceable. So you need to look at ripeness and whether there's a contractual provision. Many parties argue that until you have all the facts, smoke out all the secrets, it is premature to consider mediation or any form of ADR. As any litigator knows, you need as much ammunition as you can gather on behalf of your client before commencing the settlement battle, or at least that's the conventional wisdom of the trial lawyer. Don't ask the question unless you know the answer has been the mantra of cross-examination for centuries. I pose the question, why not? If you are committed to a confidential mediation process, what's the harm in asking that question? Sure, the answer may hurt your case or weaken your position, but it also may lead to knowledge that could aid in early resolution of the case. As the expectations of a party may change, by asking a simple question during pre-litigation mediation, you may be able to avoid the preemptive strikes and attendant cost of litigation that take the form of written discovery, depositions, requests for injunctive relief, and the literal mountains of paper being wasted by both sides of the litigation. Quite frankly, in today's business climate, every lawyer should be willing and able to counsel his or her client as to the potential benefits of pre-suit mediation. Timing. This benefit of early mediation really needs no explanation. The earlier, the better, in my opinion. Costs in terms of dollars and time, not only attorney time, but the time of executives, employees, experts, and witnesses are very substantial in most litigation. The use of early mediation can save millions of dollars and thousands of hours, not to mention the savings in terms of emotional energy, downtime, and loss of productivity that always accompanies litigated matters. Most companies are in business to produce a product or a service and not to be involved in litigation with lawyers. Find me a room full of CEOs, and I will bet you that none are fans of the practical toll that litigation takes on the day-to-day operation of business. Quite simply, the savings to be realized by early and effective pre-suit mediation and settlement are immeasurable, both to the entrepreneur and to the overtaxed court system. Economics. The relative economics are obvious. In a litigated matter, attorney's fees, court and related costs, expert witness fees, and lost employee time and energy are all substantial drains on the involved parties. The economic cost of litigating is very high and can drag out over years and can lead to the financial ruin of a business or an individual. The use of the mediation process can avoid the economic toll and drain caused by protracted litigation. While there certainly may be cases where the strategy is to cause as much economic harm to a party as possible, in my experience, such cases are few in the final analysis. The use of a qualified mediator routinely results in enormous savings, both in terms of the actual costs and the employee time and emotional energy. The normal mediation is a 1 or 2 day affair with a one-time fee that pales normally in comparison to the cost of full-blown litigation. The savings, in other words, are enormous and are obvious. Control, and this is a big issue. There is little or no risk in pre-suit mediation. The parties are in total control of the process. The uncertainty of litigation is removed from the dispute. It does not, in my opinion, show weakness to agree to early mediation. To the contrary, one can argue that the commitment to early ADR shows strength and confidence in one's position to seek a solution early on in a private, confidential matter. There need not be press releases, media coverage, or the ripple effects from the filing of a high-profile lawsuit. And frankly, no sudden drop in stock prices in a business situation. In other words, as noted, the parties are in total control of the result, not the media, stockholders, judges, juries, arbitrators, counsel, or public opinion. The decision makers, with the sound guidance of a skilled mediator and able counsel, are in total control of the outcome. Total confidentiality, and this is a biggie. This is really the underpinning of mediation and why it works. With the parties in control of the process, the concept of total confidentiality has been set in stone by the California legislature in the form of California Evidence Code sections 1115 through 1129, and also by the California Supreme Court in the case of Cassell versus Superior Court. That's Cassell, C-A-S-S-E-L versus Superior Court, 51 Cal 4th 113, and its progeny. Cassell was handed down in January of 2011 and is still controlling law in California, despite several challenges, both in the courts and at the legislative level. In a unanimous opinion, the Supreme Court engaged in a very thorough history of mediation confidentiality in California and across the country, and came to the unequivocal conclusion that the principle is inviolate. Mediation confidentiality should be broadly and liberally construed so as to foster the public policy that underlies the concept, i.e., settlement. Final resolution. Because the parties control the outcome, a binding written settlement agreement signed by all parties to the dispute is created, which by its own terms is enforceable in any court of competent jurisdiction, as was noted in the previous slide under California Code of Civil Procedure, section 664.6. The settlement contract guarantees the parties a certain outcome, a known future, and a sound basis for the ongoing conduct of their business. Contingent liabilities, which are the bane of any auditor, can be more readily identified, controlled, and eliminated by pre-suit mediation and settlement. There is no more efficient and controllable business model for early dispute resolution, in my opinion, than early and well-planned mediation. As both an attorney representing parties in litigation and as a mediator guiding parties to resolution in thousands of cases, I have personally observed that mediation is a far superior method of resolving disputes at any stage. For many years, the federal courts have had an early neutral evaluation program that encourages the practice of engaging in early settlement discussions. By this time, virtually all state courts have adopted similar methodologies that invite such a process, and there is now a pool of very well qualified mediators available to provide the guidance necessary to bring a dispute to resolution at an early stage. As I have noted, there is, of course, a need to select the proper dispute for pre-suit mediation, as all disputes may not fit the mold for early settlement. Sometimes further investigation, expert analysis, or parameter clarification is needed before early attempts at resolution are feasible. A personal injury matter, as an example, may need medical expert analysis. A trademark, copyright, or patent matter may need a market study to determine the extent of infringement or other damages. A hostile work environment claim may need further investigation by an employer. There are many other examples of everyday disputes that may not be ripe for early pre-suit mediation and settlement. However, the common thread of all disputed issues heading for litigation is time. Time before the suit is filed and the first shot is fired, when a good faith effort to mediate and settle the matter is in order. The wise business person and his or her counsel should always consider pre-suit mediation as a viable alternative to the filing of litigation after the initial analysis of the issues. And let's see what we have by way of questions. I'm looking at the chat function, or I'm looking for the chat function. And am I finding no questions? I'm not seeing any showing up. Perhaps I made my point. It was certainly a pleasure presenting this short presentation to you on pre-suit mediation. If any of you wish to get a copy of an article I wrote on this topic several years ago, it will be on our website at www.grayduffylaw.com. And I believe for those of you that registered and/or participated today, a video link will be sent to you and will be on our website. And not finding any questions, which I'm not for whatever reason, I will end the presentation. Thank you very much, and I appreciate all of you checking in, and hopefully this was helpful. Thank you much.